Hello friends, in the series on income tax cases, today we will discuss a very important case which was before the Honorable Delhi High Court, and the issue before the Honorable Court was that if the assessee buy back its shares from its shareholders at a price which is less than the fair market value as per Rule 11 UA of the Income Tax Rules 1962, so whether in that case the difference amount can be added into the income of the assessee as per section 56 subsection 2 clause 10. This issue has been decided by the Honorable Court in the case of Principal Commissioner of Income Tax versus Globe Capital Market Limited, and this case is reported in 487 ITR at page number 744, and the date of the judgment is 7th April 2026. In the present case, the assessee is engaged in share broking and undertook buyback of 28,62,500 shares at a price of rupees 313.40 per share. In the present case, when the assessment proceedings were going on, the assessing officer was of the view that since the assessee has purchased something, has purchased the asset in the form of shares, so the price at which the shares have been bought back by the assessee should be compared with the fair market value as per Rule 11 UA of the Income Tax Rules 1962, and accordingly the assessing officer calculated the fair market value of the shares as per Rule 11 UA at a figure of 370.46 rupees and added the differential amount on 28,62,500 shares, which came in the present case 16.33 crores, and made the addition under section 56 subsection 2 clause 10 as income from other sources. The pleading of the assessee was that in the present case the assessee has not bought any assets, but it has bought back its own shares, and ultimately those shares will be extinguished as per the Companies Act, so no new asset has come in the kitty of the assessee. But the assessing officer made the addition. When the matter was before the CIT appeal gave relief to the assessee on the pretext that in the present case the assessee has not bought back any of the assets, but it was for the reduction of the share capital, and it was in no sense a purchase of a capital asset, and the decision of the CIT appeal was also upheld by the Honorable Tribunal. The revenue filed the appeal before the Honorable Delhi High Court, and when the court heard the matter, the court was of the view that in the present case the assessee has purchased its own shares at the rate which has been fixed by the board of directors of the company and which was duly approved by the shareholders in their meeting. The court further said that in the present case the payment for the buying back of the shares of the company was from free reserves and securities premium. The court said that in the present case the buyback of shares is basically for the reduction of the share capital, and the company ultimately will extinguish and physically destroy the shares which have been bought back by the company. The court said that in the present case it cannot be said that income from other sources has accrued as per section 56 subsection 2 clause 10, especially in the case when there is no purchase of the assets and ultimately the share capital of the company will be reduced as per the provisions of the Companies Act. Friends, this case is very important. At the face, the assessing officer seems justified that the company has purchased some shares and which have been purchased at the rate which is not at as per the fair market value. So at the face the provision seems to be applicable for section 56 subsection 2 clause 10, but ultimately there is no new asset which has come into existence, but the share capital of the company has extinguished to the extent of the shares bought back by the company. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Globe Capital Market Limited, and this case is reported in 487 ITR at page number 744, and the matter has been decided by Honorable Delhi High Court on 7th April 2026. Friends, before parting with, I just want to convey the message that if you rely on any of the deliberation, then please read the full judgment, take the proper professional advice, and do not try to apply the case without going to the each and every content of the matter of the case, because in 5 minutes or 6 minutes videos it is very impossible to narrate all the facts, because as the facts changes the applicability of the decision may vary. Thank you friends.